episode 9 and part 2 in our mini-series on the many ways in which we can hold title to real estate. So in episode 8, we talked about holding title in the name of a trust. And now we're here today again with attorney Martha Prizio and attorney Morgan Jones to talk about what it means when a corporation or a corporate entity is the owner of a real estate property.
Thanks for having us, Jackie. So Morgan, last time we started with talking about the benefits of holding title in the name of a trust. Are there similar benefits when you're holding title to an LLC or a corporation or some other entity?
Yes, absolutely. Good question, Martha. There are some similar. You can use it for estate planning and probate avoidance because you can use the terms of the operating agreement or the corporate documents, depending on what type of entity you're going with here, to decide what happens to things after somebody passes away. So it can be used for that. And then it also gives you an additional protection for liability. And that's usually the big concern why people might choose to hold property in an LLC or a corporation as opposed to holding it in a trust, is that extra benefit of the liability protection.
And what are some of the reasons that someone would want to try to limit their liability and ownership of a property?
The most common would probably be if they're renting the property. I've seen it, I guess, most often if people they're going to stay there part of the time and then they're going to rent their ski house some of the other time, for example. Or if it's going to be rental property altogether, they might want to have that LLC in place so that it would limit their liability.
That's interesting because there is an increasing use of Airbnb and VRBO. We have another podcast on that topic. And so we're seeing a lot of these folks wanting to limit their liability because they may have a rowdy bunch of skiers or those that want to enjoy a lakefront property, and there might be some boats and other things that could cause injury on the property. And so folks are really looking at different ways to limit their liability. So would this be helpful in that regard?
Absolutely, and I agree. That's a great point, Jackie, that a lot of people are more and more doing the Airbnbs, and it can be a very good choice for that, to limit your liability when you're doing any type of rental, including short-term rental like that.
And I think what's interesting is when people who are investing may own many properties. So it may make sense actually for them to own each property in a separate entity. Isn't that right? Absolutely.
And that's probably what I see the most often is people will open up, and you can name them whatever you want. So often it's the name of the street. So it's 210 Main Street, LLC, or whatever you want to call it. But it can be a really good idea to put each one. That way it has its own separate liability and you're limited from it. That each property is separated from another, if there's an issue attaching another property with liability.
And I think that really gets to the heart of why you would create an entity that is separate from yourself. In order to get the benefits of the liability protection, what you're hoping to accomplish is really to separate the entity from yourself as an individual. And so there are some costs that go along with that, right, Morgan, in order to get the benefits.
Yes, absolutely. So your creditors or anybody to which you have liability can touch anything that you own. So if you need to separate it from yourself, if you want to be able to separate it from creditors and liability. And so costs involved, again, if you already have an LLC organized and we're just putting property into it, there would be the deed drafting and the recording fees. If you're starting up the LLC, then there's filing fees, and then there's also the cost of having somebody help you draft an operating agreement.
Now, is an operating agreement required?
It is not, but it is an extremely good idea. Highly, highly recommended for many reasons. It helps with that estate planning we were just talking about, and it also helps with really making it clear that this LLC is separate from you. It helps with that liability protection quite a bit. And then it also helps with if there's multiple members in this LLC, what happens when one person wants out? How do you deal with that? Yes, there are statutory provisions, but then you're at the mercy of the change of those statutory provisions. You don't get to be the boss of what happens to your property if somebody wants out. So I can't recommend an operating agreement enough. And as we mentioned in our last segment about trusts, we have Candace O'Neill at our office that would be happy to help people out with that in New Hampshire and Massachusetts. Again, I have referrals for Vermont until hopefully someday we'll get you some one-stop shopping here, and we'll be able to do it in-house in Vermont as well. I'm blessed enough to be so busy with real estate that I have referrals to help out with that part. And then transfer tax. So in Vermont, it really depends on how the LLC is set up, who the beneficiaries are of it, and then you only get an exemption if it's your first capitalization of the LLC. If you have a penny in there, then you don't get an exemption from transfer tax for putting property in there. So if you buy it and then transfer it into the LLC, and it's an LLC that's already formed and been capitalized, you're going to pay transfer tax twice. So you'll want to talk to an attorney and plan that so that you can decide what's best for you. It may work out to make sense to do it that way and just pay the transfer tax, or it may not. And it might be best if you can get it formed so that you're buying it right in the LLC, so you don't have to get the double hit for the transfer tax.
That's
what about
nice.
New Hampshire?
New Hampshire's very different. So historically, when putting property into an entity, owners of property were paying full transfer tax based on the fair market value of the property. And that really was a huge impediment for people to be able to take advantage of the liability protection that holding title in an entity really gives you. So ultimately, this was addressed statutorily, and now we have a statute whereby you can be exempted from paying the full transfer tax under certain conditions. And those conditions really are that no money is changing hands, and that the ownership interest isn't changing by virtue of putting it into an entity. So the owners of, let's use an LLC for example, if the owners of the entity are the members and two individuals each have a 50% interest in the property, if those two individuals currently each own 50% of the property and they put it into their entity, no money changing hands, and again that ownership structure is in place, then they're going to be able to avoid paying transfer tax, which is a huge benefit because transfer tax is very expensive depending on the value of the property.
Yep.
And so it really has been a huge improvement, and now makes it more achievable for people to maybe take title to property. Maybe you bought a property when you were planning on living in it, but as Jackie mentioned, now you're renting out the property, you're Airbnb-ing, you're traveling, and you're using that as a second home instead, and you've moved into a new primary residence. Now you can take advantage of those things without the impediment of that large fee.
I would say, though, one caution: if you already have financed the property with mortgage financing with a lender, you need to check with your lender first before you make that conveyance, because you could be triggering the due on sale clause in the provision of the mortgage, which is a default provision. So you just want to make sure that that trigger doesn't happen when you convey the property into the LLC.
And some lenders may allow you to make that transfer, but there could be certain conditions and costs. They may require a modification of the note and mortgage that currently exists with you as the individual. So just keep that in mind. So that's a good transition into, let's say you're wanting to refinance or finance the property for the first time, Morgan. What are the costs and to-do list for people to accomplish that?
So you'll want to talk to your lender, I guess, is the big overarching umbrella on that, because they may not allow you to finance while you're in the LLC, but they may work with you to finance individually and then transfer it into the LLC, just like we were just talking about. Just discuss with them whether they would consider that triggering the due on sale provision or not. So that's what I've seen the most often when people are doing residential lending, that they'll buy the property individually, finance it that way, and then transfer it into the LLC.
And some lenders will automatically put properties that are owned by entities into their commercial loan division, right, as opposed to going into the residential loan sphere. Even though the property may be residential property, you might be able to get a commercial loan, even though you may not be able to get a residential.
Yes, absolutely,
financing.
and that's another reason. Talk to your lender. Just let them know what you're trying to do, and have them help you find the best way to do it for you. And then You'll, of course, if they will allow you to finance within the LLC, you're going to need to show evidence of good standing from the Secretary of State's office. They may require you to have an operating agreement. So again, that's another reason for it to be such a good idea to have one, is that if a lender will allow you to finance within the LLC, they may require an operating agreement and that it is reviewed by an attorney. And then you're going to need a resolution, which is it shows authority for any particular person or people to be able to be the individuals acting on behalf of that entity to conduct the financing, to sign documents and that sort of thing.
And that's because oftentimes the actual owners of the entity aren't necessarily the same people who may be managing that entity, right, and managing the paperwork and executing documents on behalf of.
Yes, yeah, and without going, or that they can't all attend. If it says these two members are allowed to sign on behalf of the entity, it can also allow for just one for that, again, when sometimes people aren't able to attend a closing.
Any differences in a sale?
It's very similar in a sale. The same documents need to be provided. There's not an issue created like you may have trouble financing within the LLC under residential loans. So it doesn't create that issue. But otherwise, the documentation that you need is the same. You need the evidence of good standing, the resolution showing who is able to sign on behalf, well, actually, I guess you wouldn't need the operating agreement then, because we just need to see that you all agree of who has the authority to sell.
But that really ties into keeping your annual reports up to date and accurate, because I'd say the two most common issues we see when folks go to sell the property and they own it in an entity, one, they have unfortunately let their filings lapse.
Yes.
And people get behind on doing those pesky reports that are required every year.
Yeah.
And also not keeping up with making sure that those people that are identified as the owners and the authorized managers or directors of the entity aren't up to date and accurate on that report. And that's going to cause the need for an attorney to request more documentation than they might otherwise need. And I would say the second issue that we frequently see is that the entity itself has been abandoned. A lot of people create entities with good intentions, they want to use them, but the entity has now served its purpose. They're no longer using it as an operating entity, and they've stopped filing, and it's been really dissolved for many, many years, right?
Yes.
So ultimately, in that respect, you have two options. Either one, you have to bring the entity into good standing, and if it has truly been dissolved and no one is really using this entity for anything, the other option to avoid some of those costs and bringing something into good standing after a long dissolved, a long ago dissolution is to actually have all of the owners of the entity signing, stating that this transfer is being made pursuant to a winding up of the entity itself. So there are some ways to avoid that, but you need to be prepared to provide that documentation, right? And
yes, yeah, and I would say if you own property in an LLC and you're thinking of selling it, that's the time to double check. Hey, is this LLC still up to date? What do we need to do to get ourselves ready to be able
avoid
to
any delays, right?
Correct.
So as a listing agent, if you're a realtor and you're representing an entity that is selling, I think it's important to help give your client the heads up that they might have to get their ducks in a row and put these things together before they close. They may even be required to do these things before they even sign a purchase and sale agreement. It's certainly better to have the notice up front so that they will be ready for a sale and it won't delay the closing.
And we want to make sure that we've got all the appropriate people entering into the contract and that they have the authority to bind.
Correct. Yep.
Well, thank you, ladies, for joining us on this mini-series to discuss the different manners in which we can hold title to real estate. Stay tuned for another episode of the Real Planning Podcast.